court. He
No,
said that
no,
was his
not at all.
interpretation.
I mean, he appeared before us every day. We would never make
No,
that.
I said, of
This is
course,
probably just
I would clarify.
I mean, all that fine print, sometimes this happens, but that's all. We
No,
don't
I want to say, my lord, I want to say
It's an error,
something.
that's
I
all.
want to say, I looked into and sent it to Mr. Gopal Shankar Narayanan.
We'll never make that assumption about
No, not that, my lord. I say so. It's a question of interpretation. And I still feel that 357 doesn't exist. That's my impression, but I don't want to interfere now. I'll say so, my
you
lord.
and Mr. Gopal Shankar Narayan have to resolve this over coffee or better by the.
It's a question of interpretation by Gopal Shankar Narayan, interpretation by me. All that I wanted to say. I'll make it good, my lord, when my turn comes. In the rejoinder, I'll take 2 minutes.
The broader whether 357 is there and it doesn't change the
Yeah, that's correct.
your side or the response on the other side.
Yeah, that's correct. That's all.
We seem to be at odds with each other.
Yeah, I seek your lordship's indulgence.
Yes, Mr. Attorney.
For a small internal arrangement between us, and since the need for a historical narrative and a part of documentations to be read through, which I don't propose to do, and placing certain propositions in the context of historical narrative, we have divided job with solicitor and myself. What I propose to do is just to flag for lordship's consideration a summary of my written submission. I have my written submissions, but I want to place a summary so that just to take the court to what.
Summary,
Yes, it's available in my.
who you are appearing for, likewise for the solicitor. But as a matter of bifurcation, both of you would be appearing for the Union of India, right? All right. And so between the two of you will be appearing for the Union and the state. The rest are all for interveners, Mr. Dwivedi, Mr. Giri, Mr. Salve, Mr. Jetmalani, then Guru, and Mr. Nataraj, you will be appearing for the Union? Okay, but then all right.
Subjects are bifurcated, there won't be any repetition.
Mr. Banerjee also appears for whom?
Whom?
Vikramjit Banerjee as ASG appears for whom?
Vikramjit also would be Malord for the Union.
Can we then suggest one thing? If something remains, then that can be covered because we need not then.
Whatever timeline is given, they are our timelines, and it is always subject to your lordship's final call.
So after we complete with the first two arguments, we'll realize what canvas remains. Then I think.
But I just thought after you have taken and the attorney has taken 2-3 days. Whether Mr. Banerjee will require 1 day to argue for what would be a...
Yeah, he didn't say 1 day.
Oh, he says 1 day. That's why we were...
1 day. Therefore, I
will...
One day.
On part of my colleague. No, I'm sorry. It's a mistake on part of my colleague.
So Nataraj is 1 hour and he is 1 day. So I was wondering...
No. That is also 1 hour, but...
All right.
That is outer. Kindly correct it, Manoj. That's a mistake on our part.
All right. Yes, Mr.
Maybe as we travel along, days can become hours.
I'm sorry, Manoj, your lordships.
In the written submission.
So that we broadly know, and I'm sure after you people have finished, they will see whether they want to add something or not.
When I begin reading my brief summary.
Summary of letter submission.
Lordships could locate it's in the written submissions folder. It's titled Summary of Written Submissions. Just a 2-page document. But before I do that, I must certainly thank all my esteemed colleagues on the petitioner who brought in a lot of very insightful understanding of this emotion, passion-ridden issue and complicated from many angles. And we tried to bring our own, if possible, keeping in mind the objectivity as well as the neutrality which is to be involved in understanding this. And some American historian who said objectivity is not neutrality. Therefore, sometimes these things can become problematic. So keeping in mind, and I'm also reminded of a very famous statement made by Abraham Lincoln in 1864 in response to a border territories conflict issue. He talked about balancing the nation, losing the nation, and preserving the constitution. And he said, by general law, life and limb must be protected. But yet often a limb must be amputated to save a life, but a life is never wisely given to save a limb. I'll place that very full extract of it later on. For balancing between losing the nation and preserving the constitution, which will be my running theme in trying to say, we want to say that constitution will be preserved in the context of the processes, due processes, the fairness of the processes, and how these procedures are important for the integrity of the constitution on the one hand, and losing the nation on the other hand.
Equally, Mr. Attorney General, we can't postulate a situation where the ends justify the means also, right?
I know about that, but
means has to also be consistent with the ends.
We all of us understand that. So very often this question confronts all of us, both in personal life, public life, the politics of the nation, the dynamics of the political process, and so on. But then that is a question which definitely confronts. So how do you find answers which will probably produce the most sensible solutions? So let me try to read this summary. No factual or legal foundation. Your Lordship, please.
Is that what you're reading? Or
The
summary of it?
Summary.
Copies. Yeah. Give copies. This side. Is there? You mailed it. Lordships do not have it. Can I hand over a? Roger Cowell has got that page. Well, I proceed to read.
Yes.
No factual or legal foundation for any sovereignty argument. On a combined reading of the instrument of accession and the proclamation, followed by adoption of Article 370, all trace of sovereignty, if any, were surrendered and disappeared. The constitutional integration process of the state of Jammu and Kashmir with the Union of India, howsoever sought to be brought about, were the only object of Article 370. All principles and procedures pressed into service for the above purpose will always be considered subservient to this purpose. The power and deliberation authority of the President under Article 370 to deal with it in any manner is neither lost nor removed by reason of its exercise over a period of time, nor it can be said that the provision erased itself without intervention by any positive lawmaking power. Article 370 was conceived and designed to aid the constitutional integration process on the same line as it happened with other states. Its continued exercise over a period cannot be seen as a cloud over or a distortion of its original purpose. Any discretion exercised beyond its original purpose, seen as introducing room for whittling the constitutional integration or otherwise, can always be deliberated upon to bring about any changes in its contents or its abrogation. All judicial pronouncements in regard to Article 370 must be seen in that context as the challenges and claims placed before the court and their total view to be kaleidoscopically seen. Border states are a special class of territories of India, and their reorganization in Article 3 will deserve distinct consideration. The court will defer to the wisdom of Parliament in the choices of action relating to border states. The justiciability of decisions taken to deal with matters relating to border states may not be, as in the case of general run of reorganization of states or imposition of President's rule. The scheme and architecture of Article 356, which provides in regard to the sustenance of the fabric of the nation, will not be narrowed or compressed. The in terram argument demanding course correction or linearly tailored and need not be touchstone for ex ante tinkering in the undefinable state necessity potential of Part 18 of the Constitution. All instruments in aid of discharge of duty under Article 355, including the preamble to the Constitution, will be comprehended in the plenary power, Parliament, to engage in the reorganization scheme under Article 3. The plenary power to act under Article 3 is available even during rule under Article 356. Long-standing or similar measures in regard to reorganization are not precluded. The availability of power is distinct from any due process. A. Neither asymmetrical federalism nor any other federal features have been infringed. We'll try to make good all these arguments. No rights in relation to representative democracy have been taken away. Reorganization of states includes temporary or other rearrangement of rights to serve the integrity of federalism and the unity and integrity of the country. All rights are available for exercise only if unity and integrity are intact. The doctrine of necessity is flexible. The long history of internal disturbance, lack of availability of real measure of rights and justice are matters that can be legitimately taken into account for paving the path for due course rearrangements. No person can have a vested right in favor of a perennial state of unrest, and all instruments of law which have not subserved peace and justice have no inherent justice right to continue to exist, to right to exist or to continue. However, it is submitted that all measures taken are within the due processes granted and to be pressed into service to act in exceptional circumstances. All steps taken under so-and-so are within the standard set of provision issued during President's rule, and nothing arbitrarily designed has been provided for. All arguments and fraud and power are therefore misconceived. That's a broad summary of my submission. Just before the solicitor takes over, as part of the paragraph 7B, the last few sentences, so I looked into all the presidential proclamations, running into 120 of them, and particularly in regard to Jammu Kashmir. The suspension of provisions of Article 3, the two provisos, and various other provisions of the Constitution of India, or in terms of a convention that the presidential proclamation follows. So no deviation has taken place as far as this particular presidential proclamation is concerned. So suggest therefore either a fraud on the Constitution is completely misconceived. I'll try to make good arguments referring to the documents. So I just want to play this summary to show that the due process has been followed. There is no deviation from due processes. All fall within the legitimate aims and objects of what the two orders sought to achieve, and the Reorganization Act also falls within them.
Thank you. Thank you very much, Mr. Attorney General. Yes, Mr. Sultan.
Take these laws. But as indicated by the petitioners, Lords, your lordships would be taking a historical decision, Lord, in more than one ways. But first, this is for the first time, Lords, after 75 years, that your lordships would be considering that the privileges with which the residents of Jammu and Kashmir have been deprived of till then, till date, have been conferred. And I make this submission good, that so far, Article 370 Lord, function as a detriment between the welfare scheme flowing from the center, the constitutional right flowing from the center, and the residents of Jammu and Kashmir. But second thing, but because of this confusion, whether it is temporary or permanent, there was a kind of a psychological duality which was in the minds of one particular region of our country, though since inception of the constitution, it became part and parcel of inalienable and integral part of India, but there remained a psychological duality, whether induced or otherwise. That, my lord, your lordships would end. Judgment going either way, my lord, that position would end. And third, my lords,
The first one that he said. Mr. Solicitor, the first one, can you just in a sentence again formulate it? I somehow missed the first one.
yes. Lord, your lordships would find at the
I
end of
don't want to interrupt my learned friend, Malat, but the new volume has been added. 2 new volumes have been added, which were not there before, 2 days ago. I don't know, Malat. I may be wrong. I have no objection, Malat, but I just want to point that out.
it was added with the permission of the court before 6 days.
It was added, that's all I'm saying, Malat. The written submissions are new. I don't, I will not object to any of that because I don't believe in objecting to materials which are relevant for the court.
No,
But since the court told me.
was permitted. We mentioned your lordship.
I'm not disputing, you may have mentioned. I'm just saying, Malat. I have still no objection, Malat.
Volume 3 are your submissions, Mr.
What, my lord, your lordship, my lord, the Chief Justice would recall, Lord, what we have done is my submission, the submissions of the learned attorney, and my lord, all our submissions are placed in one volume. Our submissions, my lord, were new and detailed after, my lord, hearing them. And thereafter, my lord, in a chronological order and with continuing pagination, they form part of volume number 3.
On Monday, when the solicitor mentioned in the morning, you informed us that the list of dates which has been filed by Mr. Sibal,
Yes, that is incorporated.
you're adopting the same list of dates, but where you're adding something,
Yes.
you're putting it all together, so we don't have to flip between list of dates.
Written submissions are all new here.
Lord, this
Are
could have
all
been
new.
objected
I'm
on
not
that
disputing.
day,
I
my lord.
still am not disputing.
I believe.
I
my
still
lord,
will not dispute, and I'm just saying, Malat.
Then let's start, my lord, because
I'm only saying, Malat, I was not allowed, that's all these are all new, but I don't mind, Malat, we'll answer.
What we had, when he mentioned on Monday morning, I think we asked him whether your notice has been given to everybody, and solicitor said yes. At that stage, I told the solicitor, instead of having 5 different list of dates, work on the list of dates which Mr. Sibal has submitted. I'd also mentioned it in the course of the hearing.
That's right, sir.
And in that list of dates, add what you are adding separately, so that we know what has been the addition by the Union of India.
Not only that,
All of us have one master list of dates. That becomes much easier.
I don't know.
it would have been better if this objection would have been raised. Because let's not,
Sorry.
my lord, people are watching, let's not be, my lord, school children like objections, my lord. It was given on that very date at night.
No, it's because the
Not
court
by-
had
Apart from that,
Not
please
informed.
hold your tongue.
Document is created on 24th August, which is today. The PDF says it's created 24 August.
So I don't know how it could have been.
Mr. Prasanna,
Anyway, Malad, I think that we should go on with the hearing. I'm not objecting.
no, let's say.
You object and thereafter you are saying I am not.
Because I was told that I should not be able to add anything. I had only put some, just
No,
5
no,
pages.
whatever is,
Mr. Bal,
assuming that
your submission also, it would have resulted in many more people.
That's why, Malad, I didn't press it.
I don't
But,
think we should